The case is Hale versus MacLeod. Counsel are present. And gentlemen, since we are in a law school environment, we'd ask if you would stay around a few minutes once all arguments are over to be available for questions from the students. There's also a reception planned in the common area down to the right, and you're certainly invited and welcome to come and meet the students, and we will be there as well. So are there any preliminary matters to come before the court before we get started?
No, Your Honor.
Okay, then we will hear from the appellant. Good afternoon.
Good afternoon. May it please the court. My name is Matt Rogers. With my co-counsel, James Kilborn. We have the honor and pleasure of representing Mike Hale, who is sitting on the first row behind us. The appellant would like to reserve 4 minutes for rebuttal time.
Okay.
This appeal presents a simple issue. That's whether the first amended complaint provides sufficient details to allow Mr. Hale to pursue discovery and allow defendant Page to defend himself against the 9 claims alleged in the claims for relief. The complaint details at least 9 specific false and misleading representations taking place over 5 months, starting in March of 2020, ending in approximately on July 5th, 2020, which induced Mr. Hale to sign a document loaning a company $250,000. That company at the time likely was an insolvent and failing company, but was not represented as such by the defendants in this case.
So the case is before us today on a 12B6 motion, is that correct?
That's correct, Your Honor.
So the trial court dismissed the claims for failure to state a claim.
That's correct, Your Honor.
How do we review that judge's ruling?
That is a de novo review. Just like the trial court judge, the pleadings, the allegations of the complaint are deemed true for the purposes of evaluating the claims. In this case, the claims established that 2 experienced professionals, Mr. Page, who was dismissed, and if I may clarify, only the claims against Mr. Page were dismissed. Claims against Dr. MacLeod, the second defendant, and the company Green Farms Co. Were not dismissed. They were later dismissed voluntarily, thereby making the 12B6 against Mr. Page a final order that allowed review by this court.
So your client was a creditor to a corporation.
That's correct.
Gave funds as an investment in exchange for a promise to repay the money he lent.
Well, Your Honor mentions the term investment. That's part of the fraudulent inducement in this case, was that my client was told that it was a loan that would treat him as a secured creditor, very different than an investor or an equity investor that would have to stand in line behind the secured creditors and other creditors of the company that would be paid first in the event of some kind of insolvency like we have in this case.
Now, the debt instrument that your client has was a convertible promissory note?
That's correct, Your Honor.
Was that convertible for stock in the company?
It would have been convertible under the circumstances that allowed for a conversion, yes. In this case, Your Honor, I think it's important to note that the 2 individuals that communicated with Mr. Hale were Mr. Page, who is the one that the claims were dismissed against, who represented himself that he was an attorney who left a law practice in order to become the CEO and lead the company, in this case, Green Farms Co., that was a privately held company that was in a newly emerging industry without much public information in order to determine many of the representations that were made by Mr. Page.
The fact that Mr. Hale or Mr. Page may have been an attorney, does that impose any higher burden on him in the role in which he was acting? Legally,
I'm not certain that there is an enhanced burden. However, from a professional standpoint, I would say yes. And in this case, it's particularly egregious when you look at the nature of the claims, assuming that they are true for the purposes of getting to the next phase. And that's one of the real problems that we have in this case, is that we're not able to dig into some of the allegations and really determine with full scope and discovery as to the nature of some of the claims. What this complaint does in this instance, though, is it does identify a number of the specific confidential information that was provided to Mr. Hale that induced him to make these loans. That confidential information was attached to the complaint and is part of the record on appeal. It came in the form of a very extensive declaration, very extensive representations regarding the condition of the company, the financial condition of the company, and I would the competitive analysis of the company. The first example that is attached to the complaint is Exhibit 1, which is what's referred to as a capitalization table. That capitalization table identifies that prior to the loaning of any of the money, the company was at that point valued at $160 million. And that after the loan, provided that this series of loans was fully obtained, that the company would be worth $200 million. That's a far cry from what actually happened in this case, when approximately 10 months later, Mr. Hale learned that the company was insolvent and liquidation proceedings had started.
Now, your client, in the record reflects your client is referred to as an accredited investor.
Yes, Your Honor.
And what exactly does that mean?
Well, it's an interesting question at this point because he's referred to, or he signed a document that was prepared by the defendant in this case that characterized him as an accredited investor. Whether he is an actual accredited investor or not is something that would be subject to discovery and should be to determine whether he in fact was an accredited investor.
Is that someone who typically takes higher risk type investments?
Based on my understanding of what an accredited investor would be in this situation, it's someone that would be more sophisticated, that may have the ability to withstand losses and therefore maybe not take higher risks, but only be more capable of evaluating the risks. That's one of the situations here that's concerning, is because we had two very sophisticated defendants that were able to convince a sophisticated, or at least from a alleged standpoint, convince a sophisticated individual to loan this money. That happened over a period of time where very specific representations were made that made it appear that this company was incredibly financially sound, that it had an incredible future. It had, based on the representations, in this case, more than $160 million of sales in the pipeline.
Was there disclosure that the entire part of your client's capital would be at risk?
Your Honor, this, again, wasn't capital. This was a loan. That's one of the reasons why this is very unique, is assuming you were just a standard accredited investor, for example, then you would expect that you would have the possibility of losing your investment. But that's why this is very unique, and it piques the interest to find out why was it that these two individuals, Mr. MacLeod or Dr. MacLeod and Mr. Page, they both required, or they both promised, personal guarantees. If I can point, Your Honor, to the two letters that were identified as exhibits in the original complaint and in the First Amendment complaint, that were personal letters written by Dr. MacLeod and Mr. Page, both of which indicated that they were both had contributed significant amounts of their own personal wealth to make this business work, and that if I can quote Dr. MacLeod, as you review these materials, I'm confident you'll understand why I believe this is a strong and secure investment, and why I chose to put my personal financial balance sheet on the line. Mr. Page, in another personal letter, said very similar statements, including at the top of his letter, he represented that the company had over $100 million of deals in the pipeline today, the date of the writing that letter. He further indicated that in the third paragraph of that letter, that's why I've chosen to personally guarantee this note series, pledging my personal balance sheet, because I see the CBD green rush right around the corner, and I know in the next round of financing, Green Farms will be in the right position at the right time to seize it. Those representations and personal guarantees are part of what made this very unique and different from just an ordinary investor and equity situation.
But the personal guarantee wasn't for the entire $250,000, correct?
So each one of the individuals, and this is one of the nuances that you, in order to get into the nitty-gritty, you need to understand. The personal guarantees that were actually signed indicated that it would be a proportion relative to the ownership interests of each Mr. Page and Dr. MacLeod at that time. if you look at the details of that, Dr. MacLeod actually didn't directly own any ownership interest in the company. He owned, it appears, indirectly through a Canyon Trust entity. He owned 81% of the business, and then Mr. Page owned another 9%. So under those circumstances, there would be a 90% guarantee based on the language of the guarantees that were actually signed. I think from a legal standpoint, and this would be something that will be fleshed out as the case proceeded, as to whether those limitations in those documents should actually apply. Under North Carolina law, we have a principle that's when documents are drafted by a party, any ambiguities in those documents are interpreted against the drafter of the document. In this case, you've got language in the same document, the personal letters that were provided at the same time as the personal guarantees that were provided that appear contradictory. The language that I just read from these personal letters, it doesn't have any type of limitation whatsoever. It identifies that they put their full personal guarantee and their personal balance sheet fully at risk. So that begs a question as to whether there really should be. But I think that would be something that a trial judge would be able to evaluate if we were able to get to the next stage, have discovery, and determine what actually was said, what was meant by these documents. Again, the problem we have at this point is we don't know the true nature of the facts because we haven't had any discovery, and we just have the pleadings that were only intended to put the defendant on notice of the claims that would allow the defendant to defend the claims against themselves.
So I would presume that you made very similar arguments before the trial judge on the motion to dismiss and the hearing, and how do you get it wrong?
Your Honor, I believe that the brief establishes all the basis, the reason he got it wrong. The challenge in a 12b6 like this is that the trial judge doesn't have to identify the reasons for his opinion. From our standpoint, the complaint is an incredibly detailed complaint that identifies not only specific dates of specific Zoom conferences, specific representations that were made, but it also identifies and sets forth the documents that were provided to Mr. Hale that corroborate some of the representations that were made to him. I mean, from our perspective, we find it very hard to believe that anyone wouldn't want to take this investment based on the representations of the financial status of the company, and that its prospects, its business, along with a guarantee from a accomplished orthopedic surgeon or represented himself as accomplished, and an attorney who gave up a successful law practice to come work for this business.
You know, basically a 12b6 tests the sufficiency of the complaint,
That's correct.
and it's judged in the light most favorable to the non-moving party, which would be the plaintiff, giving them the benefit of every inference. That's the standard, correct?
That's correct.
What is the duty on the trial judge where you start attaching multiple exhibits to the complaint and you're facing a 12b6 motion? I know if there's an answer, it would convert it to a Rule 12c, and if there are affidavits, it would convert it to a Rule 56 summary judgment. So all these exhibits that you attach to the complaint on a 12b6, what does the trial judge do with that? And what impact does it have?
The trial judge is required to consider the content of those documents and as part of the pleadings. And that's why these kinds of cases are particularly difficult without those kinds of documents, and why this case is a perfect example of the kind of case that should move past a 12b6. Because we have those detailed documents and we're able to look at all the details of those documents in the context of the oral representations that were made by Mr. Hale, we can confirm that a number of those statements were that Mr. Hale otherwise would have to rely on his memory to recite in a complaint. He doesn't have to in this case because some of the information is available to us. And I think that's one of the reasons why this particular case is, again, quite astonishing that it was dismissed. I mean, we have letters, personal letters that were written identifying the status of the company. In particular, again, that more than $100 million of sales was in the pipeline. If more than $100 million of sales was on the pipeline that day that the letter was written, then the company would not be insolvent by May of 2021, less than a year later. If the company was valued at $100 million or $160 million, as was written in the capitalization table that was attached to the complaint, then the company would not be insolvent and subject to liquidation proceedings in a foreign jurisdiction.
Now, that was in Michigan, correct?
That's correct, Your Honor.
And there was a pleading for you to file a proof of claim for your client's loss in the bankruptcy or in the proceeding in Michigan. Did you do that?
So, Your Honor, this is a part of the interesting parts of this. A proof of claim was filed, but it was only filed after this complaint in North Carolina was filed and
So this
served.
was pending?
It was, and it was served before the proof of claim deadline. The other very interesting portion, and Your Honor knows from reading the complaint in this case, that's one of the remedies that Mr. Hale sought in this complaint, was that according to the venue provisions in the promissory note, it required that all disputes relating to the guarantees, and the transactions relative to the guarantees, would be resolved in Buncombe County, North Carolina. There's no, Mr. Hale didn't have any personal jurisdiction or any ties to Michigan, and in fact, the proof of claim wasn't even sent to Michigan. The proof of claim was required to be sent to an agent or some entity in California. So the proof of claim that was submitted was in fact a copy of the original complaint in this matter that was sent with an objection to the proceedings in Michigan, indicating that all claims relating to Mr. Hale should in fact be resolved in Buncombe County, North Carolina.
And that proceeding only related to the entity and not the individuals, is that correct?
That's correct, Your Honor. To the
So-
best of our knowledge, the challenge in those situations is Mr. Hale doesn't have any ties, and subjecting himself to that jurisdiction would require him to go up and argue these. We don't know what happened in the Michigan proceeding. However, there is case law that establishes that that would not relieve the personal guarantors like Mr. Page of their obligation, even if there was some kind of winding up or liquidation in Michigan.
Well, I'm sure we'll hear from opposing counsel how the judge got it right. And so, again, I go back to the question, how did he get it wrong? We've read your briefs, and if you would just go walk us through why you should go, at least they should be compelled to answer, you should be allowed discovery, or maybe this even needs to go to a Rule 56.
Certainly, Your Honor. The first that I would tell you is the claims for relief. The first claim for relief, fraudulent inducement. We established that there are 24 different paragraphs and exhibits that clearly specify the fraudulent misrepresentations that were made to Mr. Hale.
And you acknowledge that an allegation of fraud must be specifically pled.
That's correct.
There's a higher pleading requirement for that.
Absolutely, and we've done that in this case, identifying who made the representations. We walk you from the first time that Mr. Hale met Dr. MacLeod to the circumstances that led to Dr. MacLeod introducing Mr. Hale to Mr. Page as the CEO, the scope and the content of each one of the Zoom meetings that they had, the representations that were made to Mr. Hale, which include some that I've indicated here. For example, that the company was financially sound, it had $100 million in pipeline business, it was valued at $160 million. There were also some very important representations that were made to Mr. Hale regarding the process that would occur in the event of a liquidation. Those processes were not followed. In this case, the representations that were made to Mr. Hale is that an individual by the name of Mr. Van Kirk, Mark Van Kirk, would be the administrative agent. Upon the signing of the documents as represented to Mr. Hale, Mr. Van Kirk would then ensure that Mr. Hale's security interests were perfected, which would put Mr. Hale, Mr. Hale would remain a secured creditor regardless whether they're perfected, but it would, as a result of the perfection, would make him a higher priority secured creditor. That, in fact, didn't happen. Other representations that were made were that Dr. MacLeod and that Mr. Page would, in fact, remain in control of the company. That's, again, not what happened. Other representations were that that the guarantees would only apply or not apply in the event that Dr. MacLeod and Mr. Page were terminated. Based on the allegations of this complaint, they weren't terminated.
Can you address, I think some of the argument on the other side is that your client signed documents that explained, for example, an investment in this company involves significant risk and the convertible promissory notes are speculative securities. It also said that Mr. Page was, I guess it was Mr. MacLeod, was only authorized to speak on behalf of the company. Can you sort of address the things that the other side is saying that you all knew and signed such that it defeats some of your claims?
Certainly.
Overall?
I'd like to address first that Dr. Page, or Mr. Page was not authorized on behalf of the company. That argument. First of all, I believe that argument supports Mr. Hale's claims for fraud. Since 1974, North Carolina's courts have held a rule that fraud has no specific definition lest crafty men find ways to avoid the technical definition. Now, ruling that a chief executive officer who is authorized by the chairman of the board is not authorized to make any representations on the company it flies in the face of building confidence in business and would essentially invalidate just about any representation made by senior executives, and it would contradict North Carolina agency law.
Well, it seems, I'm just going to interrupt you, that there was this representation signed, that only the manager, Mr. MacLeod, could make such representations about the company? Did your client sign that, or?
Well, so the documents were signed by Mr. Hale. There's no dispute as to that. The question, I think, more goes to where was that representation made, and does it contradict the verbal representations and other representations that were made in the documents? The first thing that we know is that it does contradict the verbal representations, and that's one of the reasons why the first claim in this case is fraud in the inducement, because the verbal representations that were made to Mr. Hale was, in fact, Mr. Page could be the one that makes these representations to you, and you can trust his representations. In the briefing, we've also identified numerous locations in those same documents that identify that other individuals are able to make representations and are authorized to make representations. And I believe in 3 different locations in the documents that were also provided to Mr. Hale and signed, it references that Mr. Hale had an opportunity to ask questions and have those questions answered to his satisfaction. And that's exactly the process that Dr. MacLeod told Mr. Hale should do with Mr. Page. So again, it would contradict the representations that were made to him. I think it's also important to point out, for example, in the convertible note, if you look at note section 4, Romanet 2, the language of that gives another example of the same kind of representation that Mr. Page was authorized. The language is, quote, "The company's manager or other authorized representative has approved issuance of this note and after reasonable inquiry concerning the company's financing objective and financial situation." That specifically goes to the same issues that we're talking about, that the note affirms that Mr. Page, as CEO, was authorized to issue the note, and that he did so after he determined the financial situation of the company, and that he had misrepresented the financial situation of the company at that time. Now,
Let me ask you one thing more specifically about the unfair and deceptive trade practice claim. It was dismissed as well.
yes, as to Mr. Page, that's right.
Right, and we've got fairly extensive precedent in North Carolina that Chapter 75 claims do not apply to quote-unquote security transactions, and that a promissory note that's convertible into stock is a security. Are you saying the trial judge got that one right, or why would that not be a bar to that specific claim?
Your Honor, in this situation, I believe that this is probably the closest claim that to being dismissed properly. And the reason in this case, the case of Noble versus Foxmore, which I believe was the February of 2022 case from the North Carolina Supreme Court, it postdated the filing of this complaint. So Noble versus Foxmore, I believe, makes it fairly clear that convertible promissory notes that relate to the capitalization or the financing of a business are not in effect in commerce. So I believe that is likely correct. That's one of the reasons why, in brief, we didn't pursue that issue. However,
That's what I'm trying to clarify. I'm trying to separate the wheat from the chaff. So
Yes.
That was a claim. I want to ask you directly about that because of that controlling precedent.
Now,
And if there was any claim that, no, this transaction would not be subject to that precedent.
this, if any, case demonstrates that if North Carolina law is incorrect or should be modified, this would be the kind of circumstance that it should be modified. And the reason being is that Mr. Hale was induced to sign this promissory note as a lender, not understanding the nuances of North Carolina law. He was told he would be treated as a secured creditor, not as an equity investor or a securities holder. In this situation, for the sake of efficiency, and because there are other claims like the fraud and the securities fraud statutes, we believe that Mr. Hale has a similar remedy, and we intend to pursue those similar remedies.
As it relates to the constructive fraud claim, does that not require, and this goes back to an earlier question, does that not require a relation of trust and confidence existing between the parties?
It does, and in this situation, we have those circumstances, and that's the Keener Lumber versus Perry circumstance, where when a company approaches insolvency, and then duties arise to the creditors of the company to preserve the assets and to perform in a certain manner. And our argument in that regard follows the facts of this case, and that is once the convertible promissory note was signed, it contained obligations that required the defendants to provide Mr. Hale with financial information on a quarterly basis that they never provided. And
You agree the general rule is officers of the company do not have a fiduciary relationship with shareholders. You do
that
as
is
a general
correct.
rule.
Yes, as a general rule, except under specific circumstances like we have in this case,
Okay.
and as we've alleged.
You have about 5 minutes left if you want to.
I'll reserve that time I'd like to finish the question.
Yes.
Or if you have any other question with that regard. And the only thing that I'd point out, and I think it's important, is that following the signing of this complaint, Mr. Hale's allegations of fraud and constructive fraud and fiduciary duty, he has independent claims that relate to that because the duty arose to provide him with information. The first that he learned about this case, or that the company was insolvent, was from the Michigan liquidation. They weren't providing him with that information. They hadn't provided him with the information that his security interests weren't perfected.
Would that go more to the breach of contract claim?
Not in this situation. It could, but in this situation, it prevented him from actually exercising his remedies. One of the representations made in May of 2021 was you'll be treated as a secured creditor, when in fact he was not treated as a secured creditor in the Michigan liquidation. That's one of the reasons why it was an affirmative misrepresentation as to how he would be treated.
So that could go either to the breach of contract or to the fraud.
That's correct. And those, again, I think would be whether and how they're decided will be determined after we have discovery and we learn more information about what actually transpired.
Okay. You have 4 minutes left.
Thank you, Your Honor.
May it
Good
please the
afternoon.
court. Good afternoon. My name is Douglas Hanna. I represent the defendant appellee, Mr. Jonathan Page. Now, first thing I think it's important to understand is that this case is really a case about contract documents. It's not a fraud case. And we say that because when you look at the timeline and you look at the complaint, there were investment materials provided to Mr. Hale on July 2nd, 2020. So if you orient yourself to that date, the investment materials, as outlined in paragraph 40 of the complaint, were provided by a group called ARC Advisors, which was the broker. Mr. Hale met Mr. MacLeod in March, so just a few months earlier.
So you said there was no prior relationship between Mr. Hale and Dr. MacLeod or Mr. Page?
No, I'm saying that just from a timeline perspective, Mr. Hale meets Dr. MacLeod in March. And when you
I
look
guess
at,
my question is more, was there any pre-existing relationship between these parties but for the approach of the broker?
yes, there was. Mr. Hale and his wife were acquaintances with Dr. MacLeod's sister. Dr. MacLeod's sister told them about Dr. MacLeod. He owned some facility a climbing facility, I believe, in Asheville. Mr. Hale met Mr. MacLeod, or Dr. MacLeod, on March 8th. It was actually Mr. Hale who solicited Dr. MacLeod about investment opportunities as set forth in the complaint. In paragraph 16, at the end of their initial encounter, Hale casually referenced that Hale might be interested to help finance local business opportunities. And then a few days later, Mr. Hale emailed, actually that same day, Mr. Hale emailed Dr. MacLeod stating that Hale was looking for local investment opportunities and would love to consider participating in the initial round of funding for the hemp and CBD business. And there were
So your client's an orthopedic surgeon?
my client is, no, the orthopedic surgeon is Dr. MacLeod.
Right.
Dr. MacLeod is not my client. My client is Mr. Page, the CEO of the company. Dr. MacLeod is the member manager, the sole manager of this single manager LLC.
Green Farms Company.
Yes, sir. Yes, Your Honor. And Dr. MacLeod, the complaint indicates, was not only the majority owner, the primary investor, but he was also the manager.
So the issues before us today relate solely to Mr. Hale and Mr. Page, is that correct?
Yes, Your Honor. In fact, the trial court dismissed Mr. Page from the lawsuit at 12B6, withheld his ruling on Dr. MacLeod. Mr. Hale, the plaintiff, subsequently filed a voluntary dismissal against Dr. MacLeod and the company, and they have subsequently, on September 7th, refiled against Dr. MacLeod.
So the issues today are just between Mr. Hale as plaintiff and Mr. Page as defendant?
Yes, Your Honor. And so to go back to the timeline, Mr. Hale and Dr. MacLeod meet in March. There's some discussion about, would you like to invest in the company? Initially, there was some discussions about an equity investment. At some point in time, according to the complaint, Mr. Hale had discussions with Mr. Van Kirk, the administrative agent, who started talking about maybe it would be better to invest doing a convertible promissory note. And that, according to Van Kirk, he told Hale, and this is paragraph 32, that he was involved in structuring and documenting a convertible note, which payment was secured by the assets of GF Company and personally guaranteed by MacLeod and Page. And so the parties then decided move in that direction. And what's important is on July 2nd, ARC Advisors, the broker, sends this offering memorandum. So sends an offer to Mr. Page and indicates this is what we are selling. And as indicated in the prior questioning, the offering memorandum and the record at page 422 states no person other than the manager of the company, which is Dr. MacLeod, has been authorized to make representations or give any information with respect to the company except the information and representations contained in this memorandum. So there's a memorandum, an offer. Here are the reps that we're making to you, the company. The company is authorized to do this by the manager, Dr. MacLeod, who's in control. And Mr. Hale agrees. And Mr. Hale not only agrees to that, meaning here are the reps and it's MacLeod who's authorized, but he also himself, when he signs the convertible promissory note, makes some representations. He reps that he's sophisticated. He reps that, and this is the record at page 37, that Mr. Hale has such knowledge and experience in financial and business matters that the holder is capable of evaluating the merits and risks of this investment. He represents that he has the ability to bear the economic risk.
Would you agree, though, that all that being true, taking that as true, that even someone who's sophisticated has a right to accurate information?
Yes. He has a right to the reps that were made by the company. He has a right to that would be accurate. But as to fraud, it has to be, as stated by the Supreme Court recently in an opinion that was just entered on September 1st, there must, the Supreme Court indicated, quoting Ragsdale versus Kennedy, There must be evidence of a misrepresentation of existing or ascertainable facts as distinguished from a matter of opinion or representation relating to future prospects. And what you heard in the opening argument was talking about prospects. The company talked about prospects involving the pipeline, which is not something that's subject to a fraud claim. There are actually 9 representations that Mr. Hale indicates is that he's proceeding on against my client, Mr. Page. Those 9 representations were pulled from the briefing. We went through and created a chart for the court to explain why none of the 9 are, even if you assume that Mr. Page somehow had the authority to make reps, and even if you assume that the reps were outside of what was contained in the offering memorandum, the representations that they're complaining about in this case are not actionable in fraud. And I'll also point the court to that recent Supreme Court case where they talked about unfulfilled promises cannot be made the basis for an action of fraud. And so when you look at some of the cases that were cited, there's actually a pre-existing fact that was either misrepresented or concealed from the person that constitutes fraud. In this case, when you start looking at the 9 representations that they're complaining about, it has to do with future projections. So
You cite Ragsdale and Kennedy in the brief, the more recent case that you just cited. What is it again?
And we submitted a memorandum of additional authority
Right.
2 days ago, and that case that we're citing is, it's Value Health Solutions.
Versus Pharmacy Research Associates.
Yes, number 100A22, Supreme Court opinion filed on September 1st, 2023.
And your reliance on that case is just basically unfulfilled promises cannot be the basis of fraud.
Correct, and likewise, future representations relating to future prospects are not actionable as fraud. And when you look at before I get to the 9 representations, I do think it's important to walk through the offer that was made to Mr. Hale that he accepted, to talk about in the record what he agreed to when he signed the convertible promissory note and he invested $250,000 via that convertible promissory note. Again, that note is between the company and Mr. Hale. My client's not a party to that contract.
But your client did give a personal guarantee.
He did. He signed a personal guarantee that indicated that he would be responsible. There was a cap of 5% of his. I'm sorry. The personal guarantee that he signed indicates that there's a cap based on the percentage of ownership of Mr. Page. Mr. Page, as the documents indicate, had a 5% ownership in the company. So on the $250,000 investment, my client would have guaranteed $12,500, but that guarantee was also subject to release language in paragraph 7, which is at page 56 of the record. And the release language indicates that notwithstanding anything to the contrary in the note or this guarantee, the guarantor, Mr. Page, will be relieved of his obligations under this guarantee if the company has terminated the guarantor's employment with the company. And again, going back to the question about documents attached to the complaint, that's I think the key case is the Schlepper case, if I'm pronouncing that correctly. And that case talks about when the court indicated when considering documents attached to the complaint, the actual content of the documents controls, not the allegations in the pleadings. And so the allegation here was Mr. Page resigned, even though the guarantee says he has to be terminated. But when you look at the actual filing in the Michigan liquidation proceeding, which is, that is at page 98 of the record, that's a document that was signed by the person who has control, Dr. MacLeod, the manager. He signs the general assignment for the benefit of creditors initiating this Michigan liquidation proceeding. And when he's filed this in May of 2021, the document at record page 105 indicates a signor has terminated, or prior to its execution of this agreement, will terminate any and all of its employees, including the chief executive officer, which is my client. So he's relieved pursuant to the release of that guarantee. So that is the contract between Mr. Page and Mr. Hale, not the convertible promissory note.
So you're saying that the maximum liability he would have had in the event would have been 12.5 of the $250,000, and that only lasted so long as he was continued to be employed by the company?
Yes, Your Honor. And that's the basis of the breach of
But
contract.
that would only be termination, not resignation, correct?
Correct, and the documents that are attached, the Michigan liquidation proceeding documents indicate he was terminated, and then, of course, there's a final judgment that's also in the record from the Michigan liquidation proceeding. So if we kind of reorient ourselves back to the offer that was made, not only did the company, when they made this offer to Mr. Hale, indicate no person other than the manager is authorized, but noted that the convertible promissory notes are available only to persons willing and able to bear the economic risks of this investment for an indefinite period of time.
And to go back just really quick to finish my last question, Mr. Page signed a guarantee, but he also signed the convertible promissory note on behalf of the company, right? At the
He
same
did.
time?
Yes,
So all of this is happening simultaneously.
yes. Yes, they believe they were signed the same day. And so the offer obviously had some, this is on page 430 of the record. The offering memorandum had a section called cautionary note regarding forward-looking statements. Statements contained, so the company's telling Mr. Hale, statements contained in this memorandum, including information incorporated by reference and statements concerning the investment objective and business and other plans and objectives of the company for future operations and economic performance, discuss future expectations, and state other forward-looking information. Those statements are subject to known and unknown risks, uncertainties, and other factors, many of which are beyond the company's control, which could cause the actual results to differ materially. The company goes on to report to Mr. Hale in this offer, in light of the risks, assumptions, and uncertainties involved, no person, including the company, can assure Mr. Hale that the forward-looking information contained in this memorandum will in fact transpire or prove to be accurate, which is why, I mean, not only did he agree to this and understand that there was forward-looking information, but the Supreme Court, citing other cases, Ragsdale, has indicated these type of forward-looking statements are not properly subject to a fraud claim. In fact, the company goes on page 430 and says, the company makes no representations and undertakes no obligation to update the forward-looking information. Even though Mr. Hale's complaining, after I signed this note, I never got more information from the company, and the company's saying, we are under no obligation to update this and provide you more information. The investor suitability section on page 432 says an investment in this company and the underlying securities involves a high degree of risk and is suitable only for experienced investors. The company also reports to Mr. Hale that they will conduct the offering with the assistance of ARC Advisory Company, who will receive a 5% success fee. And ARC is the company that provided the offering memorandum to Mr. Hale. Risks,
They're not a party to the litigation.
they are not. The risks are outlined beginning on page 433 of the record. Specifically, it says an investment in the company involves significant risks and is suitable only for those persons who can bear the economic risk of loss in their entire investment for an indefinite period of time and who have limited need for liquidity of their investment. See risk factors. And the
But
other.
again, I go back to my earlier question, let's say all that is true, and unfulfilled promises cannot be fraud, future prospects cannot be fraud, but the information that someone is provided must be accurate, correct?
The representations that are contained in the offer by the company, yes. And so if there is those representations also come with, hey, there are a lot of things in here, forward-looking statements, and this is high risk, and
And I know you're not representing the company, so the questions that I would have probably are not appropriate to you for Mr. Page.
that's correct, Your Honor. But my point is, even if you look at the 9 reps, and even if I did represent the company, I would say, the claim that an investment for 10% equity would generate certain projected returns is not subject to a fraud claim. That's number one. The second, the claim that MacLeod and Page controlled, managed, and that they would remain employed by the company. That my client never managed or controlled anything. In fact, the complaint states that MacLeod was the manager, and MacLeod was the majority shareholder.
But as the CEO, your client didn't have any control over the daily activities of the company.
My client did not control the company on the decisions of selling, offering the note and filing Michigan liquidation proceedings. That's true. My client was the CEO, but obviously the guarantee, it's important to understand that the guarantee that Mr. Hale signed obviously contemplated, hey, as CEO, I might get fired. I might get terminated. The disclosures that were provided to the company provided to Mr. Hale by the company also indicate management might be subject to change. There's no guarantee that Mr. Page is going to stay on or remain on as the CEO, and that's cited in our brief. And there are 3 cases involving, trial courts looking at disclosures that were provided to someone in connection with a fraud claim. The Schlipper case that I noted earlier, ACE is the case with the airplane, selling the airplane where the broker had conversations with a North Carolina lawyer saying, if I can make sure I get that correct. The broker told the lawyer that the airplane had been excellently maintained. The airplane was subject to periodic airworthiness inspections. There was an agreement reached by telephone. The North Carolina lawyer flew down to Texas, wanted to test fly the airplane. It got late in the day, and the broker presented the buyer with a purchase agreement, and the purchase agreement said, "You're buying this airplane as is, where is." No reps are being made by the owner of the airplane. The court in that case affirmed the JNOV ruling by the trial court and indicated the court noted that the buyer read and signed the purchase agreement where he agreed that no representations were being made. There was no evidence of concealment in that case, like there is in this case, because the concealment allegations here have to do with future events, things that happened after the signing of the note, talking about the security interests and what security interests the company owed to Mr. Hale, which is not my client's responsibility, and again would be contained within the 4 corners of that agreement. So the court in the ACE case concluded that thus, because plaintiff effectively agreed when he signed the purchase agreement that defendants made no representation whatsoever with regard to the plane, plaintiff is unable to establish the making of a false representation. And I just point the disclosure cases out to you because when you start looking through the actual, what the claims are in this case, you see that they relate to either future projections, relate to claims which are defeated by the complaint itself. Number 4 talks about financial stability and superior market competition or competitive position, notwithstanding the disclosures go on and on and on about how this company is, this is a high-risk investment. There's a number of disclosures made in the offering memorandum about risk factors that we have a limited operating history upon which you may evaluate. There's another disclosure on page 439 of the record. If any of our senior management or any of our advisors were unable or unwilling to continue in their positions, our business and operations could be disrupted or fail, meaning if the CEO left, obviously in this case he was terminated. The company indicated to Mr. Hale, actual result of operations will vary from the company's projections. Not only, we don't know if this is going to be true, but it's likely it will vary. Such forward-looking statements are based on assumptions, which assumptions may prove to be incorrect. Accordingly, there is no assurance that such projections, assumptions, and statements will accurately predict future events or actual performance. So coming back to your question, if you make projections, but you let the buyer know, we don't know if these projections are going to come true. We don't know if there are a lot of uncertainties in the world that could affect our business and affect whether we're profitable. In fact,
Well, I have a question. The plaintiff alleges that representations were made to him by Mr. Page that this was a safe investment, that he would have a first-ranking security interest, and that does actually appear within the terms of the convertible promissory note. He's got a first-ranking security interest and lien on the collateral not already encumbered, but his allegations, of course, in the complaint are that this representation was made to him that this was a safe investment. So how do you respond to that?
So that's a good question, because that is one of the 9 allegations. I think it was the 9th in my chart. Mr. Page never represented it was a safe investment. It's never, the word safe appears one time in the complaint. It has nothing to do with my client, Mr. Page. It's page 32 of the complaint, where Mr. Van Kirk, the administrative agent, was talking about the merits of whether you want to make an equity investment or do we want to do this convertible promissory note. And Van Kirk, the administrative agent, is saying, I think, from my perspective, a convertible promissory note is safer than making an equity investment. It's got nothing to do with the company as a safe investment. And in fact, in the reply brief on...
So the difference being a creditor in a liquidation would have maybe some rights that a shareholder would not have, correct?
In a liquidation, the creditor has
a creditor
rights.
would have rights that a shareholder might not have.
Yes, Your Honor. In fact, the cases talk about the director, there's no case that says an officer owes a creditor duties. The cases all talk about director. The director, who's in control, and who, in this case, would control the liquidation proceedings, has certain obligations to the creditor during a winding up. And in this case, Mr. Hale, the manager, is the only person who would have those obligations to Dr. MacLeod is the only one that would have those obligations to Mr. Hale, not my client. And when you look at the complaint, the complaint talks about that the company went into insolvency in May when this Michigan liquidation proceeding was filed. So the winding up, according to the complaint, was in May. The date that the Michigan liquidation proceeding was filed by Dr. MacLeod. And my client had been terminated as the CEO. So my client doesn't owe any fiduciary duties. There's no case that says the CEO owes fiduciary duties. And I'm not sure I've finished answering your question, Judge Wood.
I think you did.
Okay. The safe. So the safe investment, what's interesting there is that, initially my client made the idea, represented that it was safe. He did not. And of course, the argument in the briefing was, hey, this brings in to play this case Latta versus Rainey. And that was one case that was argued in the opening brief. But in Latta, that there was the investors were fixed income retirees who were buying these investments in billboard investments, and the agent of the company was selling them. He was also making some sort of percentage on the sale. And the agent told the investors the company was well settled, was safe. The investors could not lose any of their principal. And he said it's absolutely no risk. But what the court focused in on there, which I think is really important, is they went back to look at, okay, what did they fail to disclose when he was saying this was safe? It wasn't just that it was, the broker was saying this was a safe investment. What the broker failed to disclose was that their principal, that these people were investing who were not sophisticated, was going to be used to fund lease payments owed to other investors. So they failed to disclose that. And the court noted nowhere in the extensive investment documentation, unlike our case, presented at trial does it state that subsequent investors' money would be funding the purported lease payments on prior investors.
That's a typical Ponzi scheme, is it not?
Yes, Your Honor. And so my
Where you're
point.
taking new investors to pay dividends to existing investors.
Absolutely. And so, again, that's nothing like our case. So these reported cases where fraud survives 12b-6 is nothing like this case. It has to do with a pre-existing fact that's ascertainable, definite, specific, that was relied upon. And here, you don't have that. Here you have the company talking about, here's our projections, here's what we hope is going to happen, but you can't rely on these because there's a lot of uncertainties in the world. Mr. Page never said it was safe. And in fact, the only time safe is ever the word safe is used in the complaint is comparing equity versus convertible promissory note.
Mr. Hale, you have about a minute and a half.
Thank you, Your Honor. So we would ask that you affirm the trial court judge's ruling dismissing my client, the CEO, based on the fact that the offer that was made to Mr. Hale, and which Mr. Hale agreed to, indicated that the manager, Dr. MacLeod, was the only person authorized, that none of the 9 statements are actionable in fraud, even if I was representing Dr. MacLeod, I would say none of these are actionable in fraud. The breach of fiduciary duty claim, I indicated my client doesn't owe any of those duties, and the breach of contract claim is likewise should be affirmed. My client, the only contract in which my client is a party to was the guarantee. My client has fulfilled the obligations under the guarantee. He was terminated under the specific release language in the guarantee. He's released. It's undisputed if you look at the contract or the documents that were attached to the complaint. He was terminated, and that releases him. So we would, again, just ask the court to affirm the trial court's order dismissing all claims against Mr. Page. Thank you.
Thank you, sir.
Where I'd like to start is to point out that the cases cited with regard to fraud, Ragsdale versus Kennedy, the Value Health case recently, the Lotta versus the Lotta case, all of those cases occurred after there was discovery, after there was evidentiary proceedings, including the most recent case, North Carolina Supreme Court case, that only some claims of fraud were dismissed at a 12b-6, but most of the claims survived and went to a summary judgment after discovery. In this case, we don't know if Green Farm Companies actually was a company that was operating that had the kind of representations that were made to Mr. Hale. We don't know, for example, if the competitive analysis that was represented to Mr. Hale was true. We don't have proof of a single sale of a product. We don't have anything to determine the pre-money valuation of $160 million, which was a then existing representation, was true. We don't know if any of the customers in the pipeline actually existed. We don't know if the farmer contracts, and this is one thing that's important, those documents that are considered as part of the complaint, they make these representations. For example, that at the time Mr. Hale signed the documents, that there were farmer contracts yielding $18 million for 2021. There were conservative estimates of $18 million per month in product sales. If none of those facts were true at that time, or if there were no actual basis for those to be true, then there is a clear instance of fraud. Now,
Let me focus down a little bit. Let's say everything you say is true, and that's the standard we've got to review your complaint. As it relates to Mr. Page, where the documents attached to your complaint provide limitations. We're looking at solely Mr. Page today and not looking at the merits of any other claims you may have against the company or Dr. MacLeod. Let's focus just on that then. Do you agree that the guarantee was limited to 5%?
only in the event that you dismiss the fraudulent inducement claims, and only in the event that you decide that the language in the personal letter written by Mr. Page, which doesn't have the limitation, should not be considered when you look at the release language. Now, I think it's important to point out with regard to that same release language that assumes facts that are not pled by Mr. Hale. It assumes, for example, that something that happened in the Michigan liquidation occurred, that he was in fact terminated. We don't know whether that's true or not. In fact, it's the document that the defendants rely on is a document signed by Dr. MacLeod, someone who has also been accused of fraud. And in this case is impeached based upon that. We don't know in the Michigan liquidation proceeding if they ever decided they were terminated or not. What we do know is, based on the allegations of this complaint, is that they represented to Mr. Hale that they weren't terminated, that they in fact resigned, and that Mr. Page resigned and Dr. MacLeod was left to sign the documents liquidating, contrary to the documents that he signed with Mr. Page.
How do you respond to his argument that unfulfilled promises or future promises are not actionable in fraud?
I agree with the legal principle, but that's not what happened in this case. As I identified a few minutes ago, there were specific representations about the amount of customers that they had, regarding this competitive position, regarding the financial revenues. There was financial information, which is another thing that I think is very important. Opposing counsel, Mr. Page's counsel, indicated that the documents that Mr. Page said that there was no obligation to provide any further information. That contradicts the language of the promissory note that was provided to Mr. Hale. In fact, if you look at record on appeal,
does it relate to his client or does it relate to the company?
No, it relates to Mr. Page, because he made the representation as the CEO of the company, which we all know that companies can't act beyond, they have to act through their officers. And in this case, Mr. Page was the officer signing the convertible promissory note that was fulfilling, promising to fulfill the obligations of the company. And Schedule 2 to that promissory note required that within no later than 60 days that unqualified audited fiscal year-end financial statements be provided, and that 30 days following the end of each calendar quarter the same financial information be provided. That's one of many instances where there's contradictory language. Now, I think it's also important to point out, and this is very important, opposing counsel, or Mr. Page's counsel, indicated that the documents were provided by ARC investors. That's not what was alleged. The documents were, what was alleged was that Mr. Page provided those documents. He then called Mr. Hale on that same day that he provided those documents and talked to Mr. Hale extensively about what was in the documents and what the language of the document meant. And the interpretation that is being expressed to you at this point now is contrary to those representations that were made to Mr. Hale at that point. That's why we have fraudulent inducement, is so that we don't have circumstances where just a written document can do away with and eliminate the verbal representations that were made. This is an attorney that was representing to a non-attorney. This is what the language in that document means. This is what you can take it to mean, and you can take it to mean that we're personally guaranteeing, we're personally putting our personal financial sheets on the line, and that the company is in fact an existing operating entity with prospects of continuing. Now, I think this is important when you look at the Lotta versus Rainey case, the Ragsdale versus Kennedy case, both of which are a long-established jurisprudence for fraud. In those cases, the Ragsdale versus Kennedy case, the representation that was made that the court found was indeed fraud was, this is a gold mine. That's all. We have significant, and that was after a jury trial, and the court said that's enough to find fraud. We have far more egregious instances of specific misrepresentations that were made to Mr. Hale in this case that needs discovery in order for us to determine. In this instance, if Green Farms Co. only had $1 million in sales, but it was represented to be a $160 million valuation company, aren't we at least entitled to determine whether there was in fact that valuation, whether that valuation was in fact correct and those representations are correct? We don't know at this point whether that's the case.
I'll give you just a few minutes to sum up.
In sum, there are many representations of material existing fact that were made to Mr. Hale that induced him to sign this document. Some of those included what appeared to be, based on the representations, making this more than an investment, but rather a secured loan that would certainly be secured by the assets of the company, that in the worst case scenario, the liquidation would occur by friendly people, Mr. Van Kirk, that would ensure that Mr. Hale's interests were paid. That didn't happen. Based on the allegations of this complaint, assuming everything that's true, we asked the court to reverse the trial court's decision, to remand back in order that discovery be had, consistent with this discovery that's in the record on appeal, so that we can find out and determine the truth of the allegations and prove the extent of the misrepresentations that were made to Mr. Hale. We also asked to reverse in part so that we can recover from Mr. Page the guarantee, whatever the amounts that a fact finder after discovery determines Mr. Page is responsible for breaching the personal guarantees signed by Mr. Page.
Thank you. Thank you, gentlemen.